Now, answering your questions about the law and legal issues. This is Legal Break with attorney Gary Bruce.
And I'm Maureen Akers. Hello there and welcome. Welcome, Gary.
Good morning.
Yes.
Good to be here.
All right, today's question, let's pull it up there. Gary, how does the Alabama collateral source law differ from Georgia?
Okay, so this is a follow-up to something we discussed earlier this summer about the collateral source rule. And so let's go back to collateral source rule, because this is a big, kind of a big deal, and juries ask about it all the time. I mean, I've seldom had a trial where they didn't say, how much did insurance pay, or did the defendant have insurance? And the point of the collateral source rule is that is not a consideration for the jury. Okay. So, and that's what the judge generally says, is that's not for you to consider. The jury is to consider what damage occurred as a result of the negligence of the defendant and whether they're responsible or not, but not whether they have a third party
helping
paying. Right. So that was the deal. So the collateral source rule says we're not going to allow evidence of third party sources like health insurance or say AFLAC disability coverage or long-term, short-term disability you might have. That is not relevant to the obligations of the defendant for what they did, the problems they created. And so don't bring it in because it's not important. Now, that's Georgia's law. That is the traditional collateral source law. I've been out of law school a long time. That's what we learned was the law 40 years ago. So, and it's always been the law. And then recently there have been some changes of, well, let's just lay it out there. I mean, insurance companies don't like it because they want to be responsible for less. So if you have health insurance in Alabama and it pays, then those numbers come in to evidence. So instead of the amount of the medical bill, then the amount to be compensated is the amount the insurance company paid. But it's complicated. It's more complicated than that. It makes sense on a simple one-liner, but application is hard.
Okay. So if they're different, as you say, then is one better than the other?
Well, I believe it's simple to use the traditional method because you don't have to take into account things like how much money did I pay for my premiums to have that coverage, so the defendant now has less of an obligation to me. And then do I just get my premiums for the month I used it?
I was going to say over what period of time, right? Yeah.
All these things, or my co-pays now come in, all these things come in. You know, there are issues with bills from medical providers. They are crazy, but it's just more simple to deal with that, and judges and lawyers deal with it after the fact, so it gets taken care of.
Thank you, Gary. See you on the next Legal Break.